Alright, closing statement, Chapter 19. Closing of the real estate transaction at the time when money with the property changed hands. Closing is also called settlement. In the years past, the seller had handed a deed to the buyer in same motion. Buyer handled the payment to the seller and party didn't release the paper to give until the paper to receive it firmly on the other hand. In past years, some local custom brokers prepare closing statements. Some done on these days according to the few questions about settlement. Most fundamental ones of the one salesperson exam. More detailed questions such as computing, prorations, and broker examination. Nowadays, almost every efforts occurs before closing. Lawyers work on for the buyer, for the seller, but not for both. Lawyers also work for lenders. Seller lender to ensure the money received the division payoff the loan will be applied to do so. The buyer's lawyer wants to be certain a seller can give a good title closing agent, often title insurance company, frequently serve as an intermediary trust by both parties. Closing agent receives the buyer's payment and settle the deed on only after everything is acceptable order does the closing proceed. Closing agent prepares accounting for both parties called a closing or a settlement statement. In the sale of real estate, numerous fees and charges must be accompanied for the closing. Ensure the change is accurately applied with the proper papers recorded with the county whorehouse. Closing agent writes checks to parties who are paid at the closing. Sometimes fees may be paid out. That's the outside closing of the POC. For example, the buyer may pay a fee with the home inspector writes some kind of POC stated on the closing statement. None of the POC fees are included in the account of the closing statement. Debit and credits of the closing statement. The general titles of change if the credits allowed. The debits are charged most made by party without, whereas credits are recognized if the party has paid something. For example, seller credits on property's price. Buyer is debited for the property price. The seller receives the cash. Is debited for money, the buyer pays cash credit within the amount of the cash paid. Total debts and credits of the seller must equal each other. The total debits and credit for the buyer must equal each other. However, the seller total debts of the credits will not necessarily equal buyer's total debits and credits. If the seller is responsible for paying the broker sales commission, the seller is debited. However, there is not corresponding entry for the buyer. It's not because of the buyer neither pay nor receive sales commission. Certain usually expenses are shared within a year with the buyer and seller sharing the items with the year is called the proration. Seller paid for the taxes full year. Buyer will enjoy partial year without paying tax collector for the expense. Then the buyer must pay for the seller closing and the portion item he will use. For example, sell $365 property tax April 1st, covering an entire year closing July 1. The buyer may pay a seller a half a year of the buyer's ownership July 1st to December 3rd, approximately $182. If the buyer is debited at $182, seller is credited at $182 because the seller paid for the tax collector for the full year. Deserves to get half the year back from the buyer. Here is a different example. Property tax for a year are due to either December 1st, closing on the March 13th. Taxes will be paid with the buyer to the tax collector on December 1st. Seller must pay the buyer approximately 72 days when the seller owned property without paying tax. The estimated annual taxes are prorated. Closing, the seller may be debited with the buyer being credited for the same amount. Prorated estimated amount is paid by the seller of the buyer at closing. Federal law called Real Estate Settlement Procedures Act applies to loan application by the personal residence, including housing, summer homes, condominium, co-op, mobile home or lot with house will be built or mobile the home can be placed. Mobile homes are now called manufactured homes. And intent of the Real Estate Settlement Procedure Act to give the disclosure prospective home buyer closing costs so they may shop at the Real Estate Settlement Procurement Act. Real Estate Procedures Act does not apply to investors to plan to remodel a house for resale, apartment complex, farmland, with or without tenants dwelling. The Real Estate Settlement Procedures Act does not apply for the farm with a new owner's residence. Real Estate Settlement Procedure Act does not regulate the amount of fees under the Real Estate Settlement Procedures Act. Within 3 business days of a loan application, the lender to give the proposed buyer a pamphlet settlement of the costs and you with a good faith estimate amount closing costs. The buyer may shop elsewhere. 1 day before closing, the buyer requests the lender to provide a preliminary uniform settlement statement with whenever loan cost figures are available at the time. Uniform settlement statement is also called the HUD-1 form. Includes all costs, fees, seller, buyer, closing copy to give to both sellers and buyers some information informs both parties. Quite some time ago, it was common practice for real estate brokers, but not salesperson, to prepare closing statements, also called settlement statements, or escrow statements for transaction they and their salespeople affected. Therefore, in traditional supplemental questions, closing statements, the payer, broker's license examination, salesperson examination, rarely anything more than an occasional, very simple question closing statement. Nowadays, although licensing laws usually require brokers to make sure that the closing statement is provided with the buyer or seller, whether common practice for someone other than broker actually prepare their settlement. Often the lender provided with a new mortgage loan for the buyer that otherwise closing will be handled in title companies, abstract companies, escrow agents. Usually, title company with the other closing agent will provide with a deed of the mortgage documents, common clerk of the record records, giving constructive notice to the of their existence. Despite the verification ownership regarding sometimes false documents, slipstream with a valid document, not recorded valid claims appear with some part losing ownership interests. The insurance exists for the reason of the mortgage lender to demand of the insurance policy over the loan amount with the cost paid someone else. Buyers can also purchase the title insurance to cover the equity of the investment. Title insurance is paid only once closing, unlike as most other type of insurance must be paid annually. The title insurance policy is issued based on the title company's attorney's title search of records kept by a county clerk at the county courthouse. Purpose of the closing statement. The closing statement provide accounting of the funds involved with the real estate transaction. Statement show the amount of the buyers must pay the seller will receive from transaction. Buyer and seller are given an account of all items then paid to bear the credit within the transaction. Broker shall be prepared for the reconciliation. Each shall with the bottom of the statement. You need not to be a bookkeeper to understand closing statement. The two columns are shown with the buyer and two for the seller. With the two columns of each party, with the debit column and the credit column, the total debit of the columns over the same party must agree with each other. Listed debit columns are almost for the party, but they may be considered the buyer or seller if the charge for listed credit column are those of the party who will receive the credit cash for the needed for the balance. A simple example is a $520,000 house in July 30th, 2018, assuming the seller has already paid $6,859.24 the entire 2008-2009 fiscal year ending June 30th, 2019. Seller should be credited with a payment of $520,000 for the house as $6,306.68 prepared tax remainder of 2018 year of July 31st, 2018 to June 30th, 2019. During the time the buyer will own the house, cash will be the offsetting debit. The buyer will be debited if the house paid up the taxes, cash offsetting the present closing, and it will appear as follows. Note, if you cannot easily tell how the $6,306.68 prorated property tax was calculated, you should review the proration section, Chapter 8. Now let's consider the same transaction, except will be added two more items. The broker and was involved at the end of the commission, $31,200, making them a sale, and also the buyer must part $300 over the survey. The seller paid the broker commission. Seller statement and show the debit of $31,200. The buyer statement shall show the debit of $300 for the survey. The new closing statement will appear as follows. Any item that affects the only one party is known as the debit or credit. Only the statement of the party affected. For example, the sales commission is paid. The seller amount will appears only in the seller closing statement. If the buyer pays for the survey, it appears only on the debit for himself. Items of value and sold, exchange, transfer between buyer and seller shown in the opposite columns. Both parties, for example, the transferred property is shown. Credit seller debit of the buyer. Never should there any item transferred, exchanged, or taken over shown as credit both parties and debited as both. An item transferred, sold, exchanged, in debit to one party and credit to the other. Items usually debited charges to the buyer likely encountered include the following: purchase price for the real property, purchase price for the personal property, deed, recording fees, title examination, title insurance, hazard insurance survey, appraisal fees, sometimes charged to seller, prepaid tax, loan assumption fees. Items likely to be credited for the buyer: earnest money, deposits, proceeds, loans he borrows, assumption for the loan, mortgage to the seller, purchase money, current taxes unpaid at closing, tenant rents paid in advance, the seller collected these, balance due to close paid by the buyer to close. Items like to be debited as a seller, sales commission, current buy, unpaid tax, existing debt where assumed to be paid off, loan prepayment penalties, discount points by the VA with the FHA loan. Discount points or conventional loans may be charged to buyer or seller depending on the contract agreements, custom in the area, local law, and so on. 6. Rents received in advance, deed preparation. Items usually created to the seller are sales price per real property, sales price, personal property, prepaid tax, prepaid insurance, only the policy assumed by the buyer, escrow balance held by the lender. Real Estate Settlement Procedure Act is a federal law that covers more residential mortgage loans due to the finance purchase 1 to 4 family properties included are housed with condominium, cooperative apartment, a unit, a lot on a mobile home, or a lot in which the house will be built, a mobile home place using proceeding a loan Purpose of the Real Estate Procedure Act. Purpose is to provide potential borrower with the information concerning the settlement closing process that they can shop intelligently. Settlement service to make the informed decision. Real Estate Settlement Procedure Act does not set the price for services. It purposely merely provides information about selling closing costs. Alright, materials to be received under the Real Estate Settlement Procedures Act. Person who filed with a loan application property covered must receive the lending agency pamphlet settlement cost in you. Good faith estimate of the cost settlement served with the lender has 3 business days after seeing the loan application mail these materials the first time and until the settlement loan application have the opportunity to shop loan settlement services 1 business day before the settlement if the loan applicant requests right to expect the uniform settlement statement pages 393 and 394 which show which figures available for the time settlement change charges the settlement with a completed uniform settlement statement is given and borrowed on his agent where this actual settlement meeting the uniform settlement statement is mailed. Uniform settlement statement at HUD 1 is discussed as usually HUD 1 form as the Real Estate Settlement Procedures Act effective transaction which include particular residential transaction form shown figure 19.1. Settlement cost in you pamphlet contains information concerning shopping of the service of the home buyers. Home buyers obligation includes sample uniform settlement statement at HUD 1 form describe the specific settlement states. Addition provide information concerning the comparison lender costs and describe reserve account adjusting between the buyer and seller. Requirements to report internal revenue for the federal tax reform of 1986 created a new requirement the brokers and settlement agencies report details some of the real estate transactions. U.S. Internal Revenue Service primary responsibility lies on the settlement agent person who is actually handled with the closing. If there's no settlement agent, the responsibility rests on the buyer's broker, seller's broker, and that order. Not all transactions need to be reported. Questions, Chapter 19. Part 5, Federal Law Affecting Real Estate.